Today I want to talk to you about an important question. Can police enter your private property, look in your car window, open your car door, and collect evidence all without a warrant? This week, we were in the Supreme Court in a case called R v. Singer, where we argued as an intervener that no, the police can't do that, at least not under a doctrine called the implied license. An implied license is a doctrine established by common law, the courts, that says police can approach a home for the purpose of communicating with the person inside, for example, by knocking on their door. But how wide is the scope of that power? The case of R v. Singer, which was at the Supreme Court, explores that question. I can't wait to tell you all about it. If you're new here, welcome. My name is Christine, and I'm the litigation director at the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing legal cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot. Also, please remember that nothing in this video is legal advice. If you have your own legal question or problem, please consult your own lawyer. So in the case of R and Singer, which comes out of Saskatchewan, the police received a phone call reporting a suspected impaired driver. So the police went looking for the vehicle and they found one that looked like it matched the description from the tip. It was parked though on a private driveway. They could see from the road that the car was running, but they couldn't see if anyone was inside. That property belonged to a man named Wayne Lester Singer. Now, to be really clear, seeing a car in this situation does not meet the criminal standard required for a search. It's not what the law calls reasonable and probable grounds that a crime has been committed. And it's not even reasonable suspicion. It's basically a hunch. The police had a tip from the public. They had a hunch it was about this car, but they didn't have a warrant to search the property or the car. But even without one, the police then walked onto the Mr. Singer's property, walked up to the vehicle, and looked in the window. Inside, they saw Mr. Singer in the driver's seat slumped over and unconscious. They knocked on the window and he didn't respond. So they opened the door and woke him up. They smelled alcohol and Singer was given a breath test, which he failed, and he was subsequently charged with impaired driving. Now, impaired driving is a serious scourge on society. The courts have held that in numerous cases. And of course, it is also a criminal offense. I take impaired driving very seriously. But I also take the Constitution seriously. What power did the police have to come onto the property and look in the window of the vehicle and open the door? How would you feel if someone walked onto your property and looked in the window of your car or opened your car door? You probably wouldn't like it. And actually, you might call the police if you saw someone do that. That's what I would do if I saw someone wandering around my property looking in my windows. Now, we intervened in the Supreme Court to say that the implied license doesn't give the police the power to do this. The implied license is very narrow. It's very carefully circumscribed. It is not supposed to be broadly construed so that police can enter property, do all kinds of things like collect evidence, which they did in this case. It doesn't give police the power to go property by property, looking around, peering in windows, opening doors, and collecting evidence, then using that evidence to charge people based on what they found. And so that's why we intervened in this case, to help the court understand and define the scope of that implied license. So implied license might sound like a technical concept, but I guarantee you use this every day. Basically, the implied license permits individuals, including the police, to approach a residence and knock on the door for the purpose of communicating with the person inside, the occupant. It represents a really narrow and specific exception to the expectation of privacy in your home. But what we've seen is over time, the doctrine of the implied license has been stretched to justify state intrusions into private property in ways that go way beyond their original narrow scope of this idea of the implied license. When I say you use the implied license all the time, it's basically the idea that you're your mailman, your Amazon delivery driver, your local Jehovah's Witnesses, they can come up to your door and knock on the door with the purpose of communicating with you. Now, you can rebut this presumption that people can enter your property to do that by doing things to rebut the presumption, like putting up a sign that says no trespassing, no soliciting, by putting up a gate and locking it. That all rebuts the presumption. But for most homes that don't do this, the assumption is you can approach the property and drop off a package if you work for Amazon. So this case, R.V. Singer, is a really interesting opportunity for the Supreme Court to reassert those boundaries of the implied license doctrine. And I think it's really important to clarify it. And we suggest a few ways that the court should think about this. First, the implied license is often referred to as a police search power. And look, I've even referred to it that way, but it's actually not a police power. It's a waiver doctrine embedded in the principles of private property. It originates from the common law of trespassing. Entry into a private property is prohibited unless it's explicitly permitted. It's not a police power. It's a waiver of the occupier's reasonable expectation of privacy, not just vis-a-vis the police, but vis-a-vis the whole world. So it applies to, as I said, missionaries, Amazon drivers, as well as the police. These strangers under this waiver are permitted to enter your property and knock on your door. And the reason this waiver exists is because there is a customary social norm that dictates that the occupier of the home, their consent is reasonably presumed in these situations. So this exists so that you don't charge your Amazon driver with trespass every time they drop off a package. Everyone is excluded from your property except for these narrow exceptions. So the general rule is that you have a reasonable expectation of privacy in your private property. That's your home and your surrounding yard. But you can waive that reasonable expectation of privacy by, for example, inviting someone into your property. And that's why we call it a waiver doctrine, because there's this implied waiver that a occupier of a home can be taken to authorize certain persons to approach the home for certain purposes unless it's rebutted by a clear expression of that intent. So a clear expression would be those examples I gave of the no trespassing sign, the no soliciting sign. But because it's implied, because we presume this based on social norms, it really needs to be limited and narrow in scope. So for example, there's an implied license that Amazon delivery guy can enter your property to drop off a package. And for that, we waive the reasonable expectation of privacy, but not that he can come and look in your windows and open your doors. We have to be very, very careful in jumping to conclusions when we're talking about the implied license. Any waiver of a reasonable expectation of privacy or any right, it needs to be voluntary and informed. For a person's consent to waive an expectation, like a right to be free from an unreasonable search, that waiver needs to be given voluntarily and in an informed way. So someone who's asleep or unconscious, like Mr. Singer was, they can't voluntarily waive their rights through informed consent. A person needs to have a requisite informational foundation upon which they consent. There need to be really high standards for recognizing waivers of rights. And they should only exist where well-known customary social norms make it reasonable to assume voluntary and informed consent to enter private property and approach a home. Now, this is sort of what we've proposed as the analytical framework for how to think about the implied license to knock. And it's similar to the one that was followed in the United States Supreme Court in a search and seizure case called Florida and Jardines. In the Jardines case, the majority held that an implied license should only be recognized when well-known customary social norms or habits of the country make it reasonable to assume that somebody implicitly consents. In that case, the court held that the background social norms that invite a visitor to the front door do not invite him there to conduct a search. So in Canada, it's the widely recognized social norm of our society is to permit strangers to approach our homes and knock on the door, but that doesn't give them the right to open that door when we don't answer in the absence of express consent to do that. So the implied license and assumed waiver of reasonable expectation of privacy, we say it shouldn't be widened to include things like police entering property on a bare hunch to snoop around, open doors, collect evidence, and then charge you with a crime. In this case, there simply is no customary social norm to ground this expansive understanding of the implied license doctrine to walk onto Mr. Singer's property, look into his vehicle windows, open the door, and then collect evidence. We also say in this case that the court should expressly recognize that the implied license is constrained not only by the purpose of the entry onto property, which is supposed to be to communicate, but also by the methods used to achieve that purpose. So put simply, the implied license allows police to walk up to a door and knock on it, but they don't authorize further intrusions into private property if no one answers the door. For example, by opening the door or by looking in the windows. The implied license's purpose exists to communicate, not to investigate. And the method to achieve that purpose is to approach and knock, not approach and open. So we say at the Supreme Court that the court should refine the implied license to clarify that it's an implied license to knock, not to do these other things, look in windows, open doors, collect evidence. This, we think, the way the courts talk about the implied license is they just call it the implied license. We think it should be amended to say the implied license to knock. And this will make it clear to courts, to Crown prosecutors, to the police, that the license ends at the threshold of the door. There's not this customary social norm that if you knock on a door and no one answers, you get to open it. The implied license ends at knocking, communicating if someone answers, or knocking and leaving if no one answers. Now, one of the other really interesting things that this case gave us an opportunity to do was emphasize that the narrow scope of the implied license is rooted in the law of trespass and its application to one of the most sacred zones of privacy protected by Section 8 of the Charter, which is the home and the surrounding yard. So we have a strong right to privacy in our home, and we want, in this case, to get the court thinking about property, which is an issue that we care a lot about at the CCF and which we think is given undue weight in Canadian law. So the genesis of the Charter protection against an unreasonable search and seizure, which is in Section 8 of the Charter, it can be traced all the way back to 18th century England in a case called Entick and Carrington, which builds on the core presumption that grounds property rights, including property rights in one's home. And Entick stands for the rule that our law holds the property of every man so sacred that no man can set his foot upon his neighbor's close without his leave. If he does, he is a trespasser, though he does no damage at all. If he will tread upon his neighbor's ground, he must justify it by law. So the core presumption that grounds property rights is the exclusion of others. If you can't exclude others from your property, do you really have a right in that property at all? Now, the seminal case in Canada on Section 8 is called Hunter and Southam. And in that case, the Supreme Court reviewed the historic evolution of search and seizure and built upon it to establish the scope of the application of Section 8 of the Charter. And in Hunter and Southam, the Supreme Court tried to widen the application of Section 8 beyond the common law protection of property. And writing for the court, Dixon responded that there is nothing in the language of the section, of Section 8, to restrict it to the protection of property or to associate it with the law of trespass. And the interests protected by Section 8 can be of a wider ambit than those enunciated in Entick and Carrington. So Dixon's holding in Hunter and Southam was meant to be expansive, not limiting. It calls for the protection of interests beyond property rights, but doesn't preclude their specific protection. Dixon emphasized that, like the Supreme Court of the United States, I would be wary of foreclosing the possibility that the right to be secure against unreasonable search and seizure might protect interests beyond the right of privacy. So in that passage, Dixon is referring to a decision from the Supreme Court of the United States called Cash Katz and the US, which extends the Fourth Amendment protection against unreasonable search and seizures to a reasonable expectation of privacy. Now, while drawing inspiration from that American decision, Katz, and its emphasis on privacy, Dixon was explicitly underscoring that, like him, the Katz majority was careful not to identify the Fourth Amendment exclusively with the protection of the right to privacy. Now, since the Katz decision, the Supreme Court of the United States has repeatedly asserted that the Fourth Amendment continues to protect property rights independently from reasonable expectations of privacy. It holds this position while simultaneously championing the slogan that the Fourth Amendment protects people, not places, a slogan that Canada's Supreme Court has also reiterated on occasion, including in that Hunter and Southern case. Now, while these positions might seem like they're in conflict, that tension, it's kind of imaginary. It can easily be dissolved by adopting an understanding of the importance of protecting people, and that includes the importance of protecting property over which they have sovereignty as recognized by law and which they need in order to develop as an independent human being. So because the implied license doctrine originates from the law of trespass and in the Section 8 context has been exclusively engaged in relation to intrusions of dwelling houses and their surrounding yards, all of this weighs in favor of a very restrained approach to the implied license. Property and privacy interests in excluding others, and most certainly excluding the state from these spaces, lie at the very core of what Section 8 of the Charter, the guarantee against unreasonable search and seizure, what that right exists to protect. So as a result of all this, we have argued at the Supreme Court that the court should be especially reluctant to expand the doctrine of the implied license in ways that further limit these really key interests. Now, look, I understand that the facts of this case are really difficult to grapple with. It involves a charge of impaired driving, which it kills people. It's a terrible social problem. It is criminal. I really hate impaired driving. I have a friend who was hurt in an impaired driving accident. Police should investigate impaired driving cases. But to do that, they need to use the tools that are at their disposal, not expand things like the implied license. Just imagine all kinds of scenarios how this could be abused. You know, you're in a fight or an argument with your husband, so you need a break. You go sit in your car outside to calm down. It's cold, so the car is running. Can the police just walk onto your property and open your car door? No, they should not be allowed to do that. The implied license doesn't give them permission to do that. Or look, maybe you just got home from a late shift at work. You're exhausted. Instead of going inside where you open the door and your dogs will start barking and you'll wake up your whole family, maybe you just fall asleep in your car. Can the police then see that your car is running and enter your property and open the car door? No, they shouldn't be allowed to do that. There are all kinds of ways in the Singer case that the police could have achieved their result. You know, a lot of time at the hearing was spent on whether or not the police could have used something called their ancillary powers. Now, we didn't intervene on this issue, so I don't know, maybe. There's also the possibility that the evidence can be admitted even if the court finds that there was an unreasonable search. There is a test for when this can be done. We weren't involved in that issue either, so I don't know. But there is one thing I feel really strongly about, and it's that the implied license doesn't extend as far as the police are claiming in this case. So I'm really curious what you think. I know that the case is hard for a lot of people because, like me, you probably really don't like drunk driving, and we want people to be charged with that. But I also don't like a totalitarian state where police can just do whatever they want in the name of prosecuting a crime. Police need to use the powers they have in compliance with our Constitution to prevent these powers from being abused against innocent people, to prevent random searches, police just walking onto your property and snooping around based on some random tip from the public or some random intuition that a police officer might have. There needs to be a threshold for entering property, and the implied license ain't it. But leave me a comment, let me know what you think. And if you want to hear about the result in this case when it comes out, you can sign up for our email freedom updates at theccf.ca/freedom updates. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.